Hello, my name is Peter Jaffe, and I'm the Director Emeritus at the Center for Research and Education on Violence Against Women and Children at Western University. On behalf of the Family Violence, Family Law Project, Keira's Legacy of Hope, Part 2, we're going to be talking about enhancing judicial education on family violence. That builds on the previous presentation by Jennifer Kagan on Part 1. I want to start with a land acknowledgement. I want you to please think about the traditional lands that you're currently situated on and join us in acknowledging and thanking the generations of Indigenous peoples who've cared for these lands and in celebrating the continued strength and spirit of Indigenous peoples. The ongoing work to make the promise of truth and reconciliation real in our communities, and in particular, to bring justice for murdered and missing Indigenous women and girls across the country should inform our discussions in this event and beyond. This presentation is a family violence, family law event. This is a project, a sister project to the Learning Network at the Center for Research and Education on Violence Against Women and Children. This project is a collaboration of 5 Alliance research centers on gender-based violence across Canada. This project is funded by the Public Health Agency of Canada. It aims to enhance training and collaboration opportunities for gender-based violence specialists and family law specialists to better support family violence survivors as they engage with the family law sector. You can check out the Family Violence Family Law website, where we post briefs, which are summaries of research on particular topics relevant to serving survivors in the family law system, legal bulletins, which are summaries of recent court decisions, and recordings of previous webinars, such as this one that'll be recorded and posted for you to share with your colleagues. In today's webinar, we are happy to be joined by 5 outstanding panelists: Erin Lee, the Executive Director of Lanark County Interval House, the Honorable Ramona Gonzalez, the Honorable George Thompson, Professor Nicholas Bala, and the Honorable Fran Kitely. I will introduce each of them more fully as each of them speaks. They're going to give you a 10-minute highlight of their remarks, and then we're going to turn to questions after each one of them has presented. To keep this webinar informal, I'm going to be addressing individuals by first names rather than referring to other titles such as Judge or Your Honor to keep this informal. Ramona Gonzalez is our first presenter. She has been serving as a state of Wisconsin circuit judge since April 1995. She became the first foreign-born National Council of the Juvenile and Family Court Judges presidents in terms of taking that office. She served on the Wisconsin Anti-Human Trafficking Task Force and is a member of the Wisconsin Judicial Committee on Child Welfare, as well as the Wisconsin Department of Children and Families and the Advisory Council of Juvenile Justice. We welcome her today, and we pass things over to her to share some information about what judicial training could look like based on the Enhancing Judicial Skills program in the U.S. Over to you, Ramona.
Thank you, Peter. I'm delighted to be here with you all today. This is a topic that is very close to my heart. Enhancing skills in domestic violence, judicial skills in domestic violence, is a crucial way for us to deliver justice to our families. I have the great pleasure of being able to participate and be a faculty member and many, almost a quarter century ago, a participant in what is called Enhancing Judicial Skills in Domestic Violence, which is a course taught here in the United States. Now, like Canada, we have a huge challenge, right? Because we have state court judges from 50 states and the territories. Everyone has their own state laws, and everyone has their own sort of way of doing things. But we found that if we brought judges together, concentrating on the skill of being a judge, and immerse them in a multi-day learning experience, that what we found was that there were moments of enlightenment that happened, and moments that in some ways were difficult. As we all know, this issue of domestic violence can be trauma-inducing, not just for the folks that come before us, but vicariously for us as well. So the National Council of Juvenile and Family Court Judges and the Futures Without Violence came together, and together with the OVW, Office of Violence Against Women, they saw the need for judicial education. I saw the first part of this seminar and was particularly taken by Jennifer Kagan's statement about the judge indicating in her case that domestic violence was irrelevant, that it didn't matter about the parenting. Nothing could be further from the truth. But that is not the normal thought process that judges go through. We are taught to listen to the facts and apply the law. But sometimes in these particular areas of domestic violence, it takes more than just listening and reacting. It takes understanding the dynamics that are happening in this family, and it's understanding how people present themselves. Perpetrators in these cases are unique in that they can be very charming, and a thoughtful response from judges is necessary in order to achieve justice. The educational program that we were able to develop looked at what are the best practices in judicial education today, because to educate judges, we have to take it from a different perspective. We're not talking about college students. We're talking about developing the inner character of a judge, to look at how to improve their integrity and their decision making. And it is about actively allowing them to participate and to understand, experimenting with the facilitators, how best to incorporate what they are hearing. Just the knowledge itself is not enough. The judge has to understand that within the construct, within the judicial independence, the judge still has to do the job by understanding the dynamics that are coming before them. Now, judges we're an interesting lot, but we all want to do a good job. And so we're motivated by being competent in the jobs that we do. We take self-satisfaction in the job that we do. And so it's important for us to not just know the material, but to be able to apply it and to enhance the ability of us to do the work on the bench. Oops. The sessions that we do in the United States were developed in 1999, and we have had the pleasure of support and funding from the Office of Violence Against Women for a significant period of time to get that done. It is a commitment in time and energy and money, especially for the judges who attend. It's a 4-day program. We provided in different areas across the country 4 times a year. And for a judge to step off the bench and leave the caseload to be for that significant period of time is a large commitment. But we have structured it so that there is practical courtroom exercises. We advise the judges on victim perpetrator behavior using experts. Fact-finding, because of course the job of the judge is particularly to get to the truth, and that means understanding how to find the facts within all of the information that's provided to you. And also there's a component of access to justice. The impact of the judge in the role as a leader in the judicial system to make justice accessible to everyone. There there are a lot of emotional issues that stop people from coming to court and asking for help, because they may very well be afraid to do so. And the judge has to understand that. And so we give them that opportunity to reflect on that. We do exercises that allow them to basically walk through a case by viewing the case from the side of the individuals who appear before us, so that we understand what it's like to live in their lives as we continue to do the work. Everyone has different cultural awareness. Judges have our own biases. We bring them into play. So the part of the curriculum is about exposing the judges to what their personal biases may be and how those impact their ability to care and decide the cases we have in front of us. And after all of that, we do actually do some work in decision making, giving the judges the opportunity to put into practice all of the concepts that we have exposed them to. And Peter has been particularly helpful with us addressing the issues of vicarious trauma with our judges, because if you sit and listen to other people's trauma, you just don't do that as an innocent bystander. And it has an impact on the work that we do. You cannot become numb to the pain and suffering of those who are in front of you. You have to stay engaged, but you also have to understand that you have to make the decisions. We had our program evaluated, and this was an interesting aspect of our educational program. When you start, we had judges rated themselves as having a deep understanding of domestic violence. Now, the majority of those judges, 63% indicated they were middle stage, and 30% said they were in the early stages of knowledge. This was 480 participants over a lengthy period of time. At the conclusion of the 4 days that they spent together, that number of those who rated themselves to have a deep understanding of this domestic violence rose to 42%. So we didn't get them all, right? But we did make an impact. We did make an impact because there were judges then who continued to grow and continued to experience the beginnings of awareness and understanding of what the dynamics of domestic violence are and how to best address these issues in court. These evaluations are, of course, self-reported, and so sometimes the things that the judges shared with us in those evaluations were quite enlightening. They were able, as a result of the 4 days they spent with us, begin to differentiate how persons might use violence in different contexts, identify cultural considerations, and make decisions and enforce decisions that led to more healthy, safe arrangements for the individuals that come before them. And I think it was particularly tough for them to examine their own implicit bias and how that sometimes played a role in the cases that they had. It was interesting to note. I think Peter and I have been doing this for almost 30 years, Peter, and I have lost count of the times when we've had judges have aha moments and sincere regret at some of the decisions that they had made before participating in this session. We try not to shame or create an atmosphere of blaming or judgment, but in this educational environment, we do allow folks to explore some of the mistakes that they've made and to think about how they can do better, because we can't go back and change what we've done, but we certainly can move forward to make life a little easier for those who appear in front of us. The study is available for you to review, and I would encourage those who are going to be putting together an educational program for Canada to consider this model to assist in enhancing the judicial skills of the individuals that appear before you. You know, judges are just human beings, and we are motivated to do the right thing. And sometimes the cases, such as the tragedy that Jennifer Kagan speaks of so genuinely and heartfeltly, and has been able to move the needle to get this educational program moving. I think that really speaks well to the future, because she has given voice to a lot of folks who did not have a voice. And it is incumbent upon us judges to hear that voice and to work together to make this system that we have put together that impacts the lives of children and families across Canada and across the United States, to do what is best to keep them safe.
Thank you very much, Ramona. And I know you'll be back for questions at the end. Our next presenter is Erin Lee. Erin is an experienced, passionate advocate who has spent decades working to end violence against women. She's currently the executive director of Lanark County Interval House and Community Support. And she's actively involved in many community committees, including a member of the Victimology Advisory Committee of Algonquin College, actively involved in training. Erin will be sharing survivor and advocate perspectives on the hopes for judicial training on family violence and things that could be covered in the curriculum. Over to you, Erin.
Thank you, Peter. Good afternoon, everybody. I am honored to be here with this lofty and experienced panel, and with all of you who are joining from all over the place. I am sitting and joining you on Algonquin territory in the east of Turtle Island. Yes, I'm happy to have an opportunity. I guess for me as an advocate, I want to make sure that we all understand that enhancing judicial education will lead to furthering justice access for victims of violence. I think it's about hearing things differently. So I want to start a little bit with what survivors would want judicial members to know. They'd want you to know that abuse doesn't end with separation. In fact, it's even more risky in the initial 60 days following fleeing or escaping of violent situations. It's very difficult for survivors to be the best possible parent if they're fearful of the abuser. Ongoing contact with the abuser, whether it's in person or otherwise through the process, has a profound and negative impact on the survivor and the children. I don't beg to suggest that judges don't understand that there are variables, and I really appreciated Judge Gonzalez's sharing of that level of education. But it's important because this is what survivors want judges to know. Abusers are not capable of engaging in the true shared decision-making process. Their motivation is power and control, not necessarily what's in the best interests of the children. Typically, abusers don't know how to compromise. Most survivors want their kids to have a relationship with their dad or with the abusive partner as long as it's safe for all the parties involved. Women experience nuances. The way he taps his finger on the table in the courtroom, the forced cough that generally meant for her to know that bad things were going to happen to her in the past, the look in the courtroom hallway. They all serve as triggers and control tactics. When women testify, they may be overly emotional due to trauma, but they may be also quite stoic for the very same reason. The need to be trauma-informed is super important and critical in terms of leading and furthering access to justice. Before going to the court to address a family matter, custody of the children, or access, for many, that seems like this is a single matter that's before the court. But in fact, it's the accumulation of years of historical, coercive incidents, control tactics, and threats. There are still inequities as it relates to the victim blaming approach in many cases. The barrage of allegations toward a victim or what appears to be inconsistencies based on her efforts to survive, protect, and endure. When things like this and these kinds of sentiments are being shared, we have work to do. The quote is something like, "You've heard the concerns that have been raised here about the family violence." This is from a judge. "There's friction in every family. And if that's the road that we're going to go down, God help us. I guess now that the legislators have opened up this family violence door, we're going to be hearing about everything that everybody did wrong to the other person going forward, and say that that should affect how the parenting time should go. But this is problematic from my perspective." This was a quote from a recent case outcome. And that to me speaks to why education must be prepared and required for everyone, and why survivors and advocates need to be engaged. So why should survivors and advocates, those who walk alongside victims, be part of developing and delivering training? I think judges need to hear directly from survivors and those who support and walk alongside them. I think that builds character. I think that informs decision making. I think it informs critical thinking. They need that personal connection to help judges understand the lived realities. Education needs to be more than statistics. It's got to be real, and it's got to be rooted in people's lived realities. Survivors and advocates can inform how the cycle works with examples and nuances from rural to urban, including generational impacts. We all know that there are several generational impacts that happen in communities, especially rural communities. Culture, faith, traditional roles, all of those pieces impact how the cycle plays out in various communities. There is no substitute for lived realities. Survivors experience what is and what isn't working to keep their families safer, and there's significant value in that. By way of example, in Ontario, we've created the first, and we host the first ever victim advocate program with the Ontario Provincial Police. These programs were inspired and informed by survivor forums that we hosted in our community. These survivor forums related to people's experience with the justice system, specifically the policing system. And this program continues to be informed by survivors, as the goal is to create and improve more positive system outcomes and experiences for victims of IPV. In my opinion, currently in Ontario, there are no better, more informed voices than those of advocates and survivors to speak in solidarity with and on behalf of the 42 women already taken at the hands of femicide in Ontario in the last 40 weeks in Ontario as of the end of August 2023. I think that when we think about the notion of judicial education, I think we need to put our money where our mouth is. Not everybody has the opportunity to make a victim impact statement. Not everybody can bring voice in the same way. But I think everybody can contribute to balancing bias with education, to be balancing bias with information. And I think we can do that more collaboratively, more collectively. And I think it will bring a much greater trusting outcome of victims and survivors who are navigating the justice system and want to be able to look to the justice system to see that justice access. I appreciate the time and I appreciate the opportunity, and I look forward to the question period that follows. Many thanks.
Thank you, Aaron, and we definitely are going to have questions for you, I know that for sure. Our next presenter is the Honorable George Thompson. George served as the National Judicial Institute Executive Director from 2000 to 2005, and he's continued to contribute to judicial education both in Canada and abroad since that time. As Executive Director, George greatly expanded the NJI curriculum, introduced skill-based courses focused on a wide range of essential judicial skills, and oversaw implementation of NJI's initial social context programming, and has been a major contributor to the field. George, I turn it over to you and your comments. George, you have to unmute yourself here.
Okay, hope I'm all right now.
Yep.
Thanks, Peter. And let me begin by joining Ramona in acknowledging the commitment and the brilliant advocacy of Jennifer Kagan in pushing for this new law, both at the federal law level and in Ontario. Keira's law for me is an important recognition of the obligation all judges have on this topic and other topics to continually strive to improve their knowledge, their skills, their understanding of both the context of their decision making and their understanding of themselves. And I'll come back to that. I just first say a little bit about how judicial education is organized in Canada. There is one organization Peter's mentioned, the National Judicial Institute, the NJI, that in the family law area plays quite a large role in the design of family law judicial education courses. And there's another organization that educates both family law judges and lawyers that Fran and Nick have played a large role in. However, a large amount of the actual education is offered by individual courts for their judges. And an individual court can decide not to free up judges enough to take the NJI courses or not to put this topic into its programming. However, the NJI can, and in this area does, play a large role in what happens at the court level. And if I could pick an example, I'm involved in the design and delivery of an NJI course to build judges' cultural capacity, and Ramon has referred to this. But here we have an annual NJI course where we can test new ways and evaluate new ways of teaching this subject to a smaller number of judges. And then we have been developing 3, 2, and 1 day courses on this subject that the individual courts, in my view, and generally eagerly take on. So in that way, we reach a large number of judges. And I think that may be a key step way to move forward here. Now, discussion about how to develop good judicial education on intimate partner violence has to deal, and it's already been acknowledged, with the important concept of judicial independence. Now, if I could quote the Federal Judicial Council, the largest oversight body for judges, the first quality of a judge is the ability to make independent and impartial decisions and to be free from outside interference. Unfortunately, these days, you can look at the US Supreme Court to just see what happens when that independent principle is lost sight of. But this can create challenges. It can mean judges can become isolated, receiving very little feedback other than the occasional appeal. There's a real risk of judges being locked into the perspectives they brought to the job. And it's just not enough, we all know, to assume they will get all they need through the evidence they receive in individual cases. But for me, this is why I believe the granting of independence is coupled with some clear responsibilities and obligations. In fact, it's part of the concept of judicial independence for me. And one of those obligations is to continually strive to build their ability to do the job by committing to judicial education as an essential part of the role. Keira's law, for me, reinforces an obligation that exists with or without the legislation, but it does reinforce it, which is important. Now, Ramona has described well what a well-designed, intensive course on this subject should look like. And just reinforce what she said by making a couple of points. The first is that there are several judicial skills that are vitally important in cases involving intimate partner violence, and there is a fairly long list of those. The skill of managing the very difficult and sensitive trial process, assessing credibility, which is crucial in many of these cases, dealing with children's evidence, managing cases where there are concurrent child protection and criminal proceedings, receiving and assessing expert evidence, making a decision, writing a judgment that communicates that decision. So it's just a broad way of saying the education that judges require is more than one course focused specifically on the topic of intimate partner violence. It's a curriculum point I'll come back to. Second, and Ramona's already said this, but I'd like to reinforce it, the education should include judges learning about themselves and the way their experience, their background, their implicit biases, the assumptions they bring to their work can shape their perspective. Broadly stated, good judgment comes from not pretending that one can come to these cases totally impartially without assumptions and beliefs. It comes from understanding one's perspective and testing it and being open to the perspective of others. So it's just a small example. It mattered in a domestic violence course I was part of at the NJI, when the judges were managing a situation where a parent had delayed contacting the child welfare agency, where the judges might assume she would, that they had had the chance to hear directly from someone with lived experience and expertise about the reasons why that delay might be quite understandable. Now, the judicial independence principle means the design and the delivery of the education needs to be judge-led. I have no difficulty with the government identifying areas of education that should or even must be within the curriculum, at least if they provide some resources to enable that to be done. But I believe the risk of interference with independence is too great if it goes much beyond that. However, here too, there's an obligation on judges leading that judicial education to use the best design methods to create education like the program Ramona has described, that uses what are called adult education methods and are presented in a way that the research tells us will actually affect the behavior of those judges after the course. So that means, for example, including those with lived experience and expertise in intimate partner violence in the design process and the teaching, not just as persons to be consulted as the law requires. And Erin has just demonstrated to all of us why that perspective is going to be so important. It mattered greatly that Pam Cross, who was on your last webcast, that she was a full member of the faculty, both when we designed and delivered the course on this subject at NJI. And as Ramona has said, it means asking the judges in the education to perform specific simulated judicial tasks with feedback in a way that enables them to identify and test the assumptions they brought to that particular task and exposes them to other perspectives, and ideally has them have to do it again afterwards. And then finally, just 4 quick points that maybe we can talk about later if there's time that would help to ensure this new law is effective. First, it's all judges who need the education. It's not just the new ones. Secondly, the education, as I said earlier, needs to be part of a real curriculum that judges work their way through, not just one course that is periodically offered. Third, and this is really important, the judges must be freed up to take the education. This is, and has been through all my time in judicial education, an enormous problem. And hard as it may be, even in tough times, Chief Justices need to accept that the pressure of work shouldn't lead them to take away the time for education so that more time can be in court. It's the wrong way to get to the right result. And then lastly, all judges should be expected to plan their education with their learning needs in mind and to be accountable to their Chief Justice for implementing that plan. Several of the problematic cases we read about in the newspaper and people have had to live through have been because there wasn't early planning to prepare a judge for work in an area that simply wasn't part of his or her work before appointment. So I'll stop there and just say, I think Keira's law was a great achievement, but what happens next is equally important. Thanks a lot.
Thank you very much, George, and definitely have questions for you when we're all done. I can see the questions start to build up on my screen. Our next presenter is the Honorable Fran Kitely. In 1995, Fran was appointed to what is now called the Ontario Superior Court of Justice. She retired in July 2021. Through most of her 45 years as a legal professional, she was engaged in family law matters. As a judge, she was involved in delivering the National Judicial Institute social context programming, and more recently, cultural competence programming. And we welcome Fran and look forward to your comments.
Thank you, Peter. And good afternoon. Am I on screen? Because it doesn't look like it from where I am.
Yes, you are.
Okay. Thank you for the introduction. I just want to expand one little detail. I became, okay, now I do not have a vision. Am I still there?
No, your screen is on, but you don't seem to be in it.
Okay, well,
We hear you. We hear you clearly, but your image isn't in the middle of the screen.
okay, well, it was before, so I don't know what the problem is. Just give me one more minute. All right, I can't solve it, so I'm going to just keep talking. And
you're very clear in your speaking.
Okay, well, let's do it that way. In Peter's introduction, he talked about when I became a judge. I became a lawyer in 1976. And let's just say that the whole realm of family law has changed enormously in those decades. And I want, before I begin my comments, to reinforce that the views I express are mine. I do not speak for my former court. As a lawyer and then as a judge, I have consistently been involved in continuing education. I'm now going to talk about my role as a consumer, a presenter, and an organizer. And I'm going to explain why I am optimistic about federally appointed judges having the skills required to preside over cases that are the subject matter of this webinar, including those involving intimate partner violence. You've just heard from George. As it happens, I've known George forever. We collaborated when I was a lawyer, and then we continued that collaboration when I became a judge. George has always been enormously creative and innovative in providing judicial education, and I think he will agree with me that an enormous amount has changed since the beginning of his involvement with the NJI. Now, I want to start with something that's going to sound really esoteric: the Canadian Judicial Council. It is a national body that includes the chief justices and associate chief justices of all federally appointed courts. In the first 10 or 15 years as my judge, it appeared the Canadian Judicial Council did not take a significant role in judicial education. However, that has changed significantly. At the end of 2017, we have a new Chief Justice of the Supreme Court of Canada, and it seems that one of the very first things that he did was become involved in prioritizing and enhancing judicial education. In 2018, the Canadian Judicial Council issued very important professional development policies and guidelines, the first time during the period that I was a judge, in which it was stated that competence and diligence are prerequisites to the due performance of the judicial office. Furthermore, the council directed the NJI that it was to design and deliver programs that would enable judges to comply with the policies and guidelines. At that time, 2018, the council said judges at all stages of their careers are expected to have an up-to-date professional development plan, but they specifically looked at judges under 5 years. Shortly after that, in September 2020, the Minister of Justice, the federal minister in Ottawa, introduced a bill about sexual assault cases. There was, if some of you remember, quite a lot of controversy then about how sexual assault survivors were experiencing their involvement in the justice system. That bill led to amendments to the Criminal Code and to the Judges Act, a very similar format for what then happened with Keira's law. After that sexual assault law was amended, the Canadian Judicial Council took another enormous leadership step in 2022 and entered into an agreement with the Minister of Justice, acknowledging the crucial point on formalized aspects of early professional development policies and guidelines. It also specified, and George has mentioned this, and it's going to come back in questions, it also specified that newly required appointed judges were mandated, to attend a seminar within the first year and another within the first 5 years. The Canadian Judicial Council has increased its commitment to transparency, to telling members of the public, what it is they're doing about judicial education. So it was in this context where the Canadian Judicial Council had already taken some steps. It was in this context that Keira's Law was introduced. There was already a consensus that expectations around judicial education had to be articulated. But Keira's Law made important progress in two respects, in my view. First, it identified the subject matters on which judicial education was required, namely intimate partner violence, coercive control, and in intimate family and partner relationships and social context. The second milestone in Keira's Law was that it required the Canadian Judicial Council to submit a report annually on the seminars that have been held. In respect to the reporting requirement, my reading of Keira's Law indicates by early March 2024, the Canadian Judicial Council will issue its first report. It will be made public. You can look at it on the Canadian Judicial Council website. But reporting on the work of the Canadian Judicial Council has already happened. Chief Justices are buying into it. And I want to ask that my first slide be displayed. This is the slide up because I can't see it. Every September, there is an event called the Opening of Courts. It happened in Ontario last week, September 28th. And the quote on the English and in French is from the Chief Justice of the Ontario Superior Court of Justice. And I won't read it, but if you will look at what he said about training on exactly the factors that were in Keira's Law. You can stop sharing the screen for that slide, please. So all of that esoteric stuff about the very important institution of the Canadian Judicial Council is that in the last 5-6 years, we have leadership in the top echelons of courts about the importance of lifelong learning for judges. The second reason that I'm optimistic is the NJI. Look no further than George Thompson, and soon you're going to hear from Nick Palla, because the NJI has responded to the challenge and continues to develop remarkable programs for judges. In my early years as a judge, the typical delivery method was a panel of 3 or 4 knowledgeable people, including judges and academics, who would discuss a topic, what we have called talking heads. The NJI is an acknowledged world leader in the design and delivery of judicial education and has been encouraged to do what it loves to do, as George has mentioned, which is to provide programs to explore creative ways of learning, including giving a voice about the lived experience to those affected by our decisions. The third reason for my optimism is that increasingly people are appointed as judges who have a background that demonstrates their commitment to continuing legal education as lawyers, who enter the field as judges, knowing that they have a commitment to lifelong learning because that's what they did as lawyers. I want to close, having said how optimistic I am about the future of judicial education and its responsiveness to the needs of the people we serve. I want to conclude about one initiative that would give me huge additional optimism. I am conscious that the audience includes people in various locales in Canada. My comments on this point are focused in Ontario. In 1977, the Unified Family Court was introduced in Hamilton. 1977. The goal of a unified family court is that all legal matters affecting the parents, spouses, and their children would be resolved in one court that would have the benefit of 2 things: significant resources and specialized judges. For many years, Hamilton was the only location in Ontario where the public had the benefit of such services. In the last 15 years or so, the model of a unified family court has been extended to 25 locations. Peter's showing up on the screen, so I'm almost done, Peter. Could I have my second slide? These are the 25 locations in Ontario where there is a family court site. For those of you who are not part of those communities, please help us do something about it. We need a family court site throughout Ontario. In order to get it in the remaining locations in Ontario, it would take the work of members of provincial parliament and members of federal parliament. Please, in those locations that do not appear on this screen, contact both your MP and your MPP and get it done. Thank you, Peter.
Thank you, Fran. And I think we'll come back to that point, hopefully during the question period, as I see some of the questions that are coming in. Our next presenter is Nicholas Bala, known as Nick to me. Nick is at the Faculty of Law at Queen's University and is a leading Canadian expert on legal issues related to children, youth, and families in the justice system. His work has been cited by all levels of court in Canada, including the Supreme Court of Canada on a recent major decision related to family violence and family law proceeding. He's frequently invited to present at continuing education programs for judges, lawyers, and mental health professionals. Welcome, Nick, and look forward to your comments.
Thank you, Peter. And like others, I want to begin by acknowledging the incredible contribution of Jennifer Kagan and the importance of the enactment of Keira's law, which is a legacy of her daughter who was so tragically killed. Family violence is certainly a very serious and widespread problem in Canada from coast to coast to coast. Historically, it has not been dealt with well by either the justice system or broadly by society. We've certainly seen significant improvements in the last 50 years, and as Fran has said, even in the last 5 years. And I would just echo that the enactment of the Divorce Act and similar legislation in other provinces has been important. Peter mentioned a very significant Supreme Court of Canada case, Berengret and Grebliunius, which specifically states that having been a perpetrator of abuse, of violence, is a significant factor in parenting cases, even if the physical violence has stopped. There is certainly much more to be done, however, to bring about change in the justice system, including changes in how judges view these cases, how lawyers and other professionals deal with these cases. One of the many challenges, however, is that it's not only family violence, but there are many other issues that are related, such as improving access to justice, hearing from children in appropriate cases, thinking about how to involve inappropriate cases in an appropriate way, non-court dispute resolution. I've had the privilege of presenting to judges in Canada, but also the United States, Australia, New Zealand, and England. And I do want to say that I believe that Canada now has a relatively good process for appointment and education of family court judges. Judges in this country, in my view, most of them are relatively sophisticated. As Fran has pointed out, having a dedicated, experienced group of unified family court judges would certainly further improve that. And there's more that needs to be done in terms of recruitment, education, mentoring, and indeed even discipline of judges. One of the issues that has been, or really perhaps our central issue here today, is, who controls judicial education? George has argued very eloquently that judges need to control judicial education. And I think, by the way, that's true of most professional groups. If you say who is responsible for deciding who does education for workers in domestic violence shelters, well, it's largely people in shelters make that decision, and who they invite, what kind of programs they have. As George has noted, the NJI that has an important role, but in fact, much judicial education is delegated, or really the responsibility of individual benches, groups of judges. The Ontario Court of Justice, the Ontario Superior Court, and so on, make their own decisions about who will be invited and how those education programs will be run, certainly with some control from, for example, the Office of the Chief Judge. I have, had the honor of being asked to present at judicial education programs in a number of countries, mainly here in Canada. And people say, well, why you, Nick? And part of it, I think, certainly has to do with the fact that I am considered an expert in the field. based on having written many articles in peer-reviewed journals. My work has been cited by the courts. I've had academic honors. That's part of it, but there's certainly more to it than that. One of the concerns that the judiciary has in organizing its programs is that the programs must appear to be balanced or at least not biased. And so the fact that I don't appear as a lawyer or an expert witness in courts certainly helps. The fact that I have experience as a teacher and have thought about issues like how to use discussion problems, how do you use videotape-based problems, and so on, is part of that. And as I said, being a law professor helps. I would emphasize that I'm certainly only one of many people who's been asked to and involved in judicial education in Canada, particularly around family violence. Professionals like Peter who work with survivors. I've had the privilege of presenting with Indigenous professionals who work with their community with survivors of family violence. Certainly one of the challenges we've heard that there are lawyers who represent and have worked with survivors. I think they have a very important role in judicial education. But there's also, I think, a need for perceived balance. There are those who represent alleged abusers who may also be asked to present. And I think that survivors have a role and have had and should have more of a role. But the general view, and I would agree with this, is that people should only be presenting a judicial education program if their experience with the justice system is long past. If they're likely to be coming to court again, it's not going to be appropriate to have them appearing in front of judges as a judicial education program. On the other hand, use of videos, use of dramatizations. For example, I've been involved in programs where we used some clips from movies like Affliction, scenes from Marriage, and so on, can really help stimulate discussion. I think it also has to be appreciated that in the family courts, there are many cases where there are conflicting claims. Judges are making very challenging decisions in the face of conflicting evidence, also making these decisions about children in particular are predictive. What will be in the best interest of the child in the future? They're making decisions about credibility assessment. Credibility assessment is not a science. And one of the realities of our justice system is that those who are making claims, including family violence, but other claims, have an onus of proof. Where the evidence is clear, where there are independent sources like police, child protection, coming forward and providing evidence, it's less challenging for judges. The real challenge in many family cases involving survivors is that the survivors may lack the resources to properly present their case, particularly lack of access to legal aid. I think that judges appreciate having presenters who can appreciate the complexity and challenges that they face, although the organizers of judicial education certainly recognize the value of hearing in different ways from those who may have experience with the justice system, and certainly hearing from non-legal presenters, as I say, people like Peter and Aaron, I think would have an important role. In my view, one of the biggest remaining challenges and continuing challenges with judicial education has been the lack of resources, and a number of people, George and others, have mentioned this. The lack of time, the lack of resources, and judicial time is one of the largest challenges. I have rarely been involved in a family law education program that goes more than a day, certainly not around family violence. We've had very few of those extensive programs of the kind that Ramona has talked about that help both increase judicial knowledge, change judicial culture, work on skills. And I think those kinds of issues are clearly very important. I think other speakers in the previous session of this program, people and really everybody, but particularly our Canada Medicar, talked about, for example, the lack of access to legal aid as being an enormous part of the challenge. And so when people are advocating for change, yes, we certainly need to do more around judicial education, but other issues, resource issues, are also going to be very important. Thank you very much.
Thank you very much, Nick. Appreciate your very timely comments. We're now going to move to questions, and I don't know if there's get any help with Fran in terms of getting her image back? Fran, do you want? There you are. So now Fran, you're muted, but we can see you clearly. So now I got to get those two things together. I guess the first question is for George. What should a Chief Justice do when deciding how to ensure his or her court is well able to handle cases and the whole range of cases, family, criminal cases involve alleged intimate family violence?
Oh, he's muted.
George, you're muted.
Yeah, thank you. If I could just comment on one thing that Nick said. I don't think in the designing of these courses that people who are involved in work before the court should be excluded from judicial education. I think the trick is, and in the one course I was most involved in, when the judges were asked to make a decision, they got to hear a range of perspectives that included the perspective of the Crown, the perspective of a person with lived experience, a researcher, a defense counsel, an experienced judge, so that the judge's own perspective is enriched. And I think that can be done with people who are actively involved in the field. But turning to your question, I think there are a lot of things a good Chief Justice can and should do. And in no particular order, I think the Chief Justice should be identifying judges on our court that are the most prepared to hear these cases and bring the most experience. And we'll have asked them to lead the effort to design courses for the rest of the court, including making use of the model courses NJI and others have produced, and identifying courses that other judges should attend. She will have committed to involving those with special expertise and lived experience, the broad range of needed voices in the design of her court education courses. She will have communicated the clear expectation that judges give real time to education every year. I think she should have sat down with each judge or required each judge of the court to plan their education, taking their learning needs in mind, and then should have, as a Chief Justice, committed to giving them time to implement those plans. I think she'll have put in special effort with Keira's law in place. I mean, in Ontario, there'll be new judges coming who made a commitment to this, in ensuring new judges are focusing on what they need to be effective in these cases, possibly aligning them with a judicial mentor to help them. And finally, I think a Chief Justice, as a form of internal accountability, will have implemented or should have implemented an annual discussion with each judge of the court to review their education plan, identify areas where more work is required, and frankly, in a helpful way, provide the judge with some feedback that she's quietly gathered from others that each judge can think about in figuring out what he or she does next to be the best possible judge. I think that's what I'd say, Peter.
Okay. Nick, do you want to make a comment on that?
So I fully agree with the idea of having a range of presenters, and good programs have that George has put together. I think, one of the concerns is if you have the compressed program and you say, we've only got an hour here, who are we going to hear from? The organizers have more concern. And so the issue that George talked about, needing the time and the resource for an educational program, is incredibly important. The way the question is put, and the way George sort of may have phrased it, is the Chief Justice has to do this. I think really the advocacy largely has to be for our politicians. Our politicians have to give adequate resources for the justice system, including for judicial education, but also including for legal aid and other things. That the Chief Justices are there, and they're, on the one hand, they're hearing from people saying, we need more judicial education, and then they have people screaming and saying, legitimately, we need access to the courts. Cases are being dismissed because there's there's not enough judicial time. So it's a very challenging role, unless and until our politicians adequately fund our justice system, in my view.
I want to just jump to Fran for a moment, because there's an issue that George raised, and a number of questions have come up about accountability. So the question around, once education is introduced, how are judges held accountable, other than appealing decisions, which we know is expensive and can take forever?
Peter, I will answer that very succinctly momentarily. I want to comment on something both George and Nick have talked about, which is judges having enough time. Time is, of course, finite. And family law is one of 3 streams of work in the court. We have a huge component of criminal work, a huge component of civil work as well. And if I were a Chief Justice today, I would probably need a third more judges. There's only so many hours in a day, only so many judges. And so, family violence is important, but there are other subject matters which take a lot of time. Plus, with the pandemic, we got a little bit behind. We being courts got a little bit behind. And now we're trying to hurry up and get rid of backlogs. Okay, so let me answer the question about accountability. As long as I have been a judge and think I still am a judge, I think that the lack of accountability by judges is unfortunate and ought not to be tolerated. For a very long time, the only outcome for a judge who was reported to the Judicial Council was to lose his job or her job or their job. There was no incremental discipline. There was no steps that a court or a Chief Justice could take to deal with anything. Thankfully, that has changed. Just like leadership in the Canadian Judicial Council has changed, there is a bill that passed in the Parliament for federally appointed judges as recently as June. And finally, we are going to have a system of incremental conduct and performance issues. And by way of example, for lesser kinds of conduct that don't deserve a judge to lose his, her, or their job, there can be things like education, maybe some health courses, maybe an apology. So the whole issue of judicial accountability is about to change.
Thanks, Fran. Coming back to another topic, Ramona, we've heard the word credibility in a number of presentations, and the challenge that family violence often takes place behind closed doors, and judges are going to be faced with conflicting accounts of what happened. There may be no medical evidence or police reports. Are judges actually trained to make findings of credibility, and how would that even begin to happen?
Well, I think, Peter, that is the sum and substance of what a judge's job is, right? Every day, all day, we hear in not just family court, but in every other court, we're there to judge the credibility of the folks that come in front of us. That's a particularly difficult thing if you have put your implicit bias in place, because if what you're hearing is through the lens of what you want to hear, you're not going to see the truth behind what's happening. That's a little convoluted, but basically, judges need to be trained, and they're not always trained because they're always talking about their experience, but judges need to be trained in how a traumatized person has presented themselves. The difficulty of telling the story from one point, from the beginning to the end, without a lot of variation. A lot of the things that judges have, and society, quite frankly, have taken as an indicia of credibility are not applicable when you're looking at a person who has suffered trauma. So the judges in my jurisdiction and the judges that attend the Enhancing Judicial Skills in Domestic Violence, they're beginning to get that information, but I think we have a long way to go. So the days of my gut tells me whether somebody's telling the truth or not are, I think, long gone, and we have to get much more sophisticated. So are they trained? Probably not formally. Should they be? Yes.
And related to that, Aaron, there's been some discussion and some questions coming in about the importance of survivors with lived experience presenting to judges. Actually, we have a question from a lawyer who's a survivor themselves, and and wonders about presenting herself based on her lived experience. My question is, you think that's important for judges to hear from survivors? And obviously on the other side of that, do you think there's danger in that you become biased by hearing from survivors?
I think they're great questions. I guess I would prefer to reframe the notion of bias to the notion of balance. I think day to day, what we know is that people who've experienced violence are often those who are silenced. They've been silenced as they've endured. They've been silenced for many years. They may have been silenced by their community. And I think that judges certainly can be informed by hearing from survivors. My goal would be, or my thought would be, that it would be to a degree that would inform decision making, that would inform their understanding of the cycle, that would build capacity for judges to recognize some of those signs and those nuances, to ask the right questions, or ask different questions, or maybe shift the lens just a tad based on having been informed by survivors. I think survivors are the best people to demonstrate, how the cycle really plays out. So when we talk about the honeymoon and the cycle and the way it perpetuates itself, I think it is helpful to have those lived realities to really break all those stereotypes and those barriers. It happens to lawyers, it happens to judges, it happens to professors. Likely everyone on this screen knows somebody who has been impacted or has survived or is enduring violence. So, for me, every day we're inundated with social media and other information that screams about various voices that are often the loudest and the most heard. And I think that there is absolutely a place for the voices of victims and survivors to not be silenced and to be encouraged to share. And I don't see that as bias. I see that as building balance and building equitable access to justice.
Thanks, Aaron. Nick, got a tough question for you. Many litigants who go to court can't afford a lawyer. Those who do may not be able to afford an assessment or an expert witness, but yet they want to make sure the court's educated on family violence issues. And as you know more than anyone, litigants can't pick the judge. The judge is the judge you get, and you don't do a pre-test. So the question is, how does a survivor, somebody advocating for a survivor, make sure that the judge has the knowledge without being able to call an expert? And part two of the question, I hope you're writing this down. Part two is are there things now that are common sense, or things that you need, an expert for? And I'll just, two common examples I think about are delayed disclosure. Why do you take, 10 years to disclose this when there's a police station around the corner? Or why did you recant? So it's a complicated question, but what do you do if you can't get an expert to court? How do you lay the foundation? And what do you need a foundation for? What's common sense, and what do you need specialized knowledge for?
So it's a great question, and it doesn't have a single simple answer, but there's a legal concept known as judicial notice, which, if you want to put it in the terms that you've put your question, what should judges be aware of without expert evidence being called? There is a legal test for this. Certainly, one of the really important things is, and one of the important sources, what's the Supreme Court of Canada or what are courts of appeal in a jurisdiction saying? And here we've had some very important decisions really in the last year and a half or 2 years from both the Supreme Court of Canada and other courts, expanding what can be considered, what must be considered by a judge in dealing with family violence cases. And certainly lawyers need to be aware of that. And, understand we were focusing on judicial education. I get phone calls from lawyers sometimes who are dealing with these cases who are really not familiar with the case law. So it's not only the judges, it's the lawyers. And again, like the judges, many of these people are overworked, particularly if they're doing legal aid work, overworked and underpaid, in fact. But looking at various sources, and the exact scope of judicial notice is itself controversial. Some of you may know there's a question of, can judges, is it a matter of common sense that that the COVID-19 vaccine is effective and safe. And that's been litigated. Different judges have different views. So that particular issue seems to be being resolved by courts of appeal on a case-by-case basis, at least in Ontario and Canada. But around the issues you're raising, I think certainly there's enough case law and enough literature that's accepted as authoritative that the issue of not disclosing right away, why is there delayed disclosure, or the fact that a perpetrator may say, well, she didn't report to the police right away or to the Children's Aid Society, so it mustn't be true. I think that is largely a matter of now that the judges do take judicial notice of. But and Ramona has in her own way pointed this out, who your judge is may really matter. And so if you're an advocate or a self-represented litigant, you can say to the judge, I think I'm asking you to take judicial notice and see what the judge says, if you need to, about some specific issue. So it's a challenging but very important issue.
Thanks, Nick. A question that's come up, back to you, George and Fran. This could be a toss-up, or both of you give a perspective. There's a concern about whatever training is done. Is it one and done? Is it only for new judges? Is it for existing judges? Do you have to be re-educated after 5 years? George, do you have any comments about how we implement the training for everyone?
Well, as I said earlier, I think the training has to be part of a curriculum, and it can't be one course just as a judge is appointed, important as that course is. But obviously what we know in this field changes over time. So even an experienced judge must come back and relearn and re-understand the things that perhaps were less than perfect the last time around. And as I say, there are a number of other skills that are required, like the skill of assessing credibility, where some specialized courses are required. So for me, this is something that should be reflected in a lifelong commitment to judicial education. And the judge who wants to be effective in this and other areas needs to be setting aside an appropriate amount of time each year to build on what they've learned before and to return to education that they've done earlier in their career.
Fran, your comments on that?
Yes. First of all, on this 5-year business, as I mentioned, this was first arose in 2018 when the Canadian Judicial Council was taking this leadership role in it, and it focused then on new judges. It became mandatory later in the 2020 for the 5-year judges. So why 5? Well, for one thing, when you're a new judge, everything is new in your first 5 years. After you've been there for a while, typically you settle into the kinds of things you're doing. So, for example, there are some judges who after 5 years will appear to the court to be very experienced and skilled at, I'm going to pick a topic, insolvency law, people going bankrupt. It's a very, very intricate kind of law. They're probably going to do that for the rest of their career. There are a whole lot of people that focus on criminal law. We have enormous volume of cases in criminal law. And after they settle into the beginning of their career, they're probably going to do that. So my point is there's a whole bunch of judges that you do not want to take public resources to educate because they are not going to come across these kind of cases. For those who are, as I mentioned, in 2018, the Canadian Judicial Council is committed to lifelong learning. And I'm hoping that as the years unfold, that the Chief Justices are going to put flesh on those bones and specify exactly what is required.
Okay. Thanks, Fran. We have a question that I think, Aaron, I want to get your perspective first and then get some legal thoughts on. Many survivors writing in saying that they're often involved in multiple court proceedings where the left hand doesn't know what the right hand knows, where their survivors are in criminal proceedings and then family law proceedings, and they're different judges. And do you have any reflections or thoughts from a survivor's perspective about how difficult that is to make sense of multiple proceedings where people don't seem to be talking to each other?
Yeah, I mean, I think that it certainly contributes to ongoing risk for those trying to navigate the various conditions and the various in the various courts. And so, I think, as we know, there have been some successes in trying to flag files so that the judicial system has a better sense of who might be in multiple courts at multiple times for multiple situations. I think that risk mitigation is one of those things that translates into safety in the world that I navigate regularly with victims, and I think that it's very frustrating. Often feels devaluing, and often contributes to a choice being made around whether to or to not, and that can certainly have detrimental impacts based on what the courts or the lawyers may find appropriate, because a decision was made to not, because the conditions in the criminal from the criminal matter suggest this and the other in family. So I think there's definitely risk mitigation. I think there's often confusion and reluctant choices having to be made that unfortunately result in consequences that perhaps could have been rectified earlier.
Okay, Ramona?
That's a really interesting dynamic, though, Peter, that goes on, because it's not just, I find, not just for my user of my court system that's a problem, but for judges as well. Because we don't know what other judges are doing in the other courtrooms. That makes it difficult for us to have the facts necessary to adjudicate what I have in front of me. The criminal judge who has the criminal case in front of them may be imposing conditions of release that would impact my family court case. And many of my colleagues have a tendency to judge these cases completely differently, whether we're in a family court case where it's like, okay, they each deserve to have both parents, versus the criminal case where I've got a prosecutor saying, okay, he's out of the house and doesn't have any contact at all. And many times folks are sort of caught in the middle between different courts and different judges with different perspectives. So making sure that they're able to communicate, that the various judicial organizations basically that are working with one case can know what the other hand is doing, I think is crucial to the safety.
Peter, if I can contribute to that, because it gives me an opportunity to go back to the Unified Family Court. This is part of the current court system, particularly in Toronto, that may be crazy, quite frankly. We would have a case going on in Toronto about parenting, child support, spousal support, property. We'd have all of those things. But something happened and the Children's Aid Society became involved. It doesn't matter how they got involved. So we then have this protocol where do we have to let everything in the child protection court play out before we can carry on in our court with all these other issues? If we had a unified family court in all places in Ontario, we would not have that problem. Insofar as the criminal aspect is concerned, I agree with Judge Gonzalez. For years in Ontario, we had a really big problem where criminal judges were releasing people on certain conditions that were really not healthy for the family. Well, over years, I actually don't know mechanically how it happened, but over the years, those front-end criminal judges were encouraged to put a condition of release subject to any order that the family court might make on supervised access or something like that. So we actually made huge progress. But please get that list of 25, find out if you're on it. Get a unified family court in your location, and that problem will get addressed.
Okay. Thanks, George.
Yeah, I don't want to end on a down note here, but when I was involved in designing these courses, we did one on managing the family law case with family violence involved. Then we did managing the criminal law case with allegations of violence. Then we tried to do a course of half family judges and half criminal judges on how to manage cases that are in front of both the family and the criminal court. And I came away from that with two conclusions. One, they don't know how to talk to each other, and they didn't even know how to do it in the education program. And secondly, we need to do a lot of work to redesign the education on that issue.
Okay. Nick, something optimistic?
Yeah, so I should say this is certainly a very important and profound issue, the communication between and the knowledge in this context. How much do the family judges know about what's going on in criminal court? The new legislation actually says judges should do whatever they can, and parties should do whatever they can to inform judges about what's going on in other courts. As Fran has pointed out, in Ontario, there have been efforts, particularly involving Crown, so training people in other systems to deal with it. There are certainly systemic changes that she has identified. So, unified family courts. In Toronto, we actually have a program of integrated domestic violence courts where we have one judge dealing with the criminal and the family case for part of it that seems to be working very well, which requires, again, political will to see that kind of is done and can disseminate more widely. I would say another thing that was alluded to here, but in Ontario in particular, or a number of other provinces, Quebec as well, Canada's two largest provinces, we do not have legislation that allows for a order to be made, a exclusive possession order to be made, domestic violence orders that most of the Western provinces have allow a victim without a lawyer, and the police will be supporting getting an immediate interim order. And that a critical period of separation, getting an order from a court excluding a perpetrator, an alleged perpetrator, on an interim or ex parte would call it an immediate basis, urgent basis. And Ontario desperately needs that kind of legislation. And again, that's something where political change and leadership are important, and where we can learn from other provinces. I should say many American states have this as well.
And one last question, and then we're going to wrap up. And I know we could easily go on for 2 more hours with the excellent questions. So one theme that keeps coming up in the Q&A is about coercive control, and how do judges learn to understand coercive control. Coercive control is a brand new piece of the Divorce Act, and is also now integrated in provincial territorial legislation in most places. So just in 30 seconds or less, how do we educate judges on coercive control? What's the challenge? And what do you think some of the remedies will be? And then just in the limited time we have. Nick,
Peter,
you go ahead, Fran.
Very quickly go back to my first slide, which is what the Chief Justice of the Superior Court in Ontario said last week, that training is going to happen on coercive control. So I don't know what the course is going to look like, but there's a commitment to do it. So maybe Nick and George can describe the course.
I would hope, Peter, that there are audio visual aids and exercises, actual practical exercises that are used to demonstrate that, so that judges have an opportunity to see what may be happening in the homes of the folks who come in front of them, because reading this stuff off a plain piece of paper just doesn't give you the same sense of what these folks really are experiencing, and actually showing them.
Nick, your hand is up. Any comments on that, or you're muted?
Muted.
While he's muted, perhaps I could just say that I would agree with Ramona, what you were saying 100%. And I think that starting with definitions and starting with having warning signs well documented, and what are some of the steps and things people can do to disrupt and interrupt coercive control, especially from a judicial perspective, if it's happening in the courtroom, in fact. And I think also, I just want to say, being open to having survivors and advocates at the table, having those discussions and informing how they could be part of that, not deciding for or prescribing or perceiving what survivors' roles might be, but actually engaging them and inviting them to the table to reduce the intimidation of the systems that often are the ones that they don't want to navigate. I think that would be a very hopeful piece that we could all be doing together. Sorry, Nick, I just used the time while you were on mute.
I got the red flag. that we're going to lose our connection soon. So I'm going to have to go to the last slides. And in closing, if we can get the last slides on. Just before ending, I wanted to just highlight for all the participants that if they have ideas, you've obviously heard lots of ideas today. If you want to share feedback to impact judicial training, the National Judicial Institute has a link on their website where they're looking for inputs about issues relevant to judicial education. So it's an opportunity to give some feedback. So the link is both on the slide, and we're going to share that link in the chat box. We have to wrap up. I wish we had 2 more hours, and obviously we need to do more sessions about this. I want to thank our presenters, Ramona, for taking the time today, Aaron, George, Fran, and Nick for a very rich discussion. We had, there was still 50 questions we didn't get to, but there's certainly lots of food for thought in terms of future webinars. I want to thank our excellent French language interpreters, and I'd also like to thank all the participants and bearing with us while we had some technical difficulties in the beginning. Please don't forget to complete the evaluation form in order to receive a certificate of participation, and a link will automatically open in your browser after the event has ended. We look forward to seeing all of you at the next event. And again, special thank you to Ramona, Aaron, George, Fran, and Nick. And I sent you an email if you would like to debrief. Ramona, if you don't have to be back on the bench, if any of you are free to debrief, I know you might have other commitments. I sent you a separate link to your email. Otherwise, have a good afternoon and evening. And again, thank you very much for being with us today. Bye for now.